Good evening. Can anybody hear me? Hi, good evening. Matimba, can you hear me?
Loud and clear, lecture.
Okay, that's cool. That's wonderful. Okay.
Thank you.
Great. Okay, I see you. Are you the only one that has arrived now so far?
Yeah, let's keep moving. They're gonna chase the bus.
Okay, so now how far have you gone now, Matimba? Is this your first time that you're here? You've joined before? Matimba, is this you've been in these classes, the LLW2602 classes before, have you?
Can you hear me?
I can hear you, yeah.
Oh yeah.
And I just want to know, have you attended any of the previous classes?
Only one session lecture.
Only one session, huh? Okay. Okay. And how are you finding it? Are you having any difficulty with any areas?
Yeah, lecture. I think by next week I will know better, man, because I haven't prioritized the modules, which I will write them earlier, you see. So this one I put it on reserve since I will write in a later stage. So there is a congestion in front of it. So I was busy with those modules.
I see.
Then by next week test I will speak.
Okay. That's fine. That's fine. Have you done the other course, LLW2601?
No, I didn't do that.
You didn't do that one?
I didn't do that. I did human resource management, 2601.
Okay, because you know, this is the other course, individual labor law, focuses on the smaller employer-employee relationship. You know, the rights of employees, and a very focused sort of approach to the rights of employees. You know, and the collective labor law is, when we look at the same law, but on a larger scale, employees have now come together and they get certain other rights, you know. So it's an examination of that relationship. What course are you registered for? Are you doing a BCom, a BA, a diploma? What are you doing?
A BA admin.
Business. Yeah. BA admin.
Okay. Yes. Okay. Bachelor of Business Admin actually. BBA. Yeah.
Okay. Business administration.
Yeah, boo.
Okay. Okay. Give me a second. Try and share my screen with you.
Okay.
Okay. So can you see the screen?
Yes.
Okay.
I can see collective labor law.
Okay. Right.
Okay.
Have you got the textbook also? The one by McGregor and Decker, Labor Law Rules, 3rd edition?
Okay, or else I can open my laptop. I got the PDF file.
Of the book.
Yeah, well, of the book, yeah.
Okay, no, that's fine. Not a
Yeah.
problem. But before we, it is important that you understand these basic concepts. Before we, proceed on the topic, I will assume now, I will just go through some of the notes that I've prepared, and make you understand what the subject is about, collective labor law. And, it is better to be able to understand the subject if you've done individual labor law, So let me very quickly start with telling you what that is about. The individual labor law, like I mentioned, it is a focused thing on the particular rights that an employee, a person who is considered employed, is afforded. And it's a study of that contract, basically. To become an employee, it is the Labor Relations Act defines that somebody who does work for somebody in exchange for remuneration, or he assists somebody in the carrying on of his business, is an employee. It's a very wide definition. But the definition, in the definition itself, it says it is this is what an employee is, but it doesn't include an independent contractor. So the distinction between an employee and an independent contractor is very important. Because if you are considered an employee, you then get all the rights of the various labor laws. Okay, but the minute you fall outside of that definition of an employee, these rights are not, you're not entitled to all these rights. So just as a way to start now, what are the most common labor laws that we deal with when we speak of labor law? Can you mention a few statutes, acts of parliament that are very common?
Yeah, it's a Labor Relations Act.
Oh, yes.
Yeah, then the basic conditions of employment, something like that. And
Yes,
the
Basic Conditions of Employment Act, yeah.
yes. Then you've got equity, something to do with
Employment
the
Equity Act, yeah.
yeah,
Employment Equity Act, yeah. Okay. Right. And there is also. Yes, continue. Yes, you're right. All those things are valid. So in individual labor law, the focus was on studying those acts, how they relate to the individual labor employment contract. Okay.
Yes.
So one has amazing rights under even individual labor law that is given and afforded to employee, a person who's considered an employee. But now in this course, I can't labor too much time on it, but in this course, what happens if employees now, the relationship between an employer and an employee is not an equal one? Traditionally, it has never been seen as an equal relationship. I mean, even today, the perception is still that an employer enjoys a higher position compared to his employee. Right? The bargaining position is not equal. The whole outlook, from a capitalist system is that the person who has the money, who has the business, who has the assets, it's his business. You need to follow his instructions so that he can pay you. So what would happen now that the relationship wasn't equal? Labor laws gives, individual employees these rights, the Basic Conditions of Employment Act gives you the right to minimum basic conditions of employment. It regulates your work hours, your work times, your leave, these kinds of things. It prevents employers from exploiting you, an individual worker. But what happens now when we really expand now and we give all these rights to many people, to many workers, to many employees? It changes the bargaining position now of the employee. Right? In a small company, in an individual labor law relationship, with the less employees, the employer will still maintain sort of that edge in the sense that, he will dictate terms, and only thing that stops the employer basically is the law. Otherwise, the employer will want to get the maximum that he can out of, or she can out of employees. So that has changed. The Constitution has afforded workers certain rights. Okay, and when we come to the Constitution itself, it speaks of these rights that are afforded to it under what we call organizational rights, in terms of Section 23 of the Constitution. Now, these terms here: freedom of association, trade unions, employers' rights, collective bargaining, workplace forum, strikes and lockouts, pickets and protest action. As you will see now, as we go on, these are all things that emanate from the rights, these organizational rights that the Constitution gives us. Now, what is this concept of freedom of association?
Freedom. Freedom of association. It grants the freedom to the employee to form or join the trade union of their choice.
Right.
To participate in the legal activities of the trade union. A right to strike.
But you see, that is a build-up. Yeah, that is basically the right to strike comes afterward. Initially, if you are an impressive employer, if you are an employer who realizes that, look, I can't allow these guys who work for me to stand together, right? That if they do stand together, they can disrupt my business. They will have some kind of hold over me. They will have the ability to disrupt my business. They can create problems, and therefore I can't allow them to stick together like this. If they stick together, they will have power against me as the employer. So this is what the constitutional right to freedom of association is about. Okay, it's this general right of freedom that you can, in the workplace especially, you can associate with anybody in the workplace that you want to. All right, everybody, not just the workers. Because you will come to see, the workers, of course, have this right. They can form groups, they can form trade unions, they can do all these union activities. So how far does this right go? Can they come together now for whatever purpose? They can't come together for wrong purposes or unlawful purposes. They can, of course, come together for the main purpose so that they can engage the employer and come to terms with him. That is the purpose of this right. It is not so that they can come together and do criminal activities or rise up against the boss, so to speak, and do things that go against the law. That is not how far the right of freedom of association goes. Okay. For now, it is that general right so that you can join whoever you want in the workplace. Now, let us look at what the Constitution says here so that we can break it up for us. Can you see the slide?
Yeah, boy. But can you promise me something, man, lecture? Can I have an access to these notes after the session? Because I don't want to congest my mind busy writing on the other side while I need also to follow you step by step.
Yeah, it's not a problem.
Okay.
You can do that. The thing, the notes, the notes are basically extracted from, various sources, including the textbook. And yes, no problem. So this is Section 23 of the Constitution. Here you can see everyone has the right to fair labor practices. Now, this is an important thing, and the Constitutional Court had to decide on this section already. Section 23, subsection 1. Everyone, does it say every worker or every employee? It says everyone. as the right to fair labor practices. So what does fair labor practices mean? There's this one particular case called Kiley versus the CCMA, a constitutional court case. I don't know if you ever heard of this case. No. But basically, remember the LRA, the Labor Relations Act, has very clearly defined who an employee is. So for you to get the rights under the LRA, under the BCEA, under the EEA, under all these other rights, under all these other labor laws, as we call them, you would have to be considered an employee. Is there anybody that is excluded? Independent contractors are excluded, right, from these rights because the Labor Relations Act expressly excludes them. But now in this particular case, the Constitutional Court interpreted this and said everyone can mean even people that shouldn't be here and that are doing things that are being exploited, although they're not getting the rights under the other labor laws, they still have constitutional protection under this section here. You understand? So in the case of Kiley, this woman, she was a prostitute. And she was exploited. And she wasn't paid the money by someone that had hired her for these things, You could call it a pimp probably, And the woman took this matter to the CCMA for, she was dismissed and wasn't paid. And the CCMA said, well, ma'am, you have to, for us to help you, you must prove that you were an employee, number one. Number two, you must prove that you were dismissed. So she had to prove there was an employment contract. Now, our law does say that such kind of activities is not recognized, Things like prostitution, it's an immoral contract and therefore it cannot be enforced. So they said, well, you can't get protection under the Labor Relations Act. But she took this matter to the Constitutional Court, and the Constitutional Court said, yes, you can't get protection under the Labor Relations Act or under the labor laws, but under this term here, everyone, and you see it highlighted there, has the right to fair labor practices, including even a woman like this who was exploited. So the court said, we're not going to look at what she did, but we're going to look at how she was treated. And this woman was cheated, and she's entitled to fair labor practices, even when she's being exploited. In fact, especially if they are exploited, they can still turn to the Constitution for help. And the people who owe the money had to then order to compensate her for the apparent work that she did. Okay, so this everyone's Section 23, subsection 1 is a very broad right and includes also employees as well as non-employees under this particular heading. Now we start to see what rights the Constitution affords. There is a bit of a sound here. Okay, it's gone now. Thank you. Did you mute?
I was just changing my devices, lecture. The speaker,
okay.
Yeah, I use the headphones, but now I changed to the ones for computer.
Okay. You can just put it on mute and then you can speak, as we. Right. So what are the rights that the workers have? The right to form and join. Every worker has the right to form and join a trade union. B, to participate in the activities and programs of a trade union. And C, to strike. Okay. So it is enshrined in our Constitution, the rights that the worker has. These are rights. And in the workplace, many employers who are either unaware or who do not care, who don't believe that people should have these things, will be well advised that if they dismiss somebody for exercising these rights, they are in big trouble. Okay, the Labor Relations Act, Section 187 makes it, calls it what we call an automatically unfair dismissal. if you, the employer, dismiss somebody for exercising any of these rights. Now, the right to form and join a trade union and participate in the activities of the trade union and to strike are all further elaborated in which act? Where, in what law do we find these particular provisions to tell us, to spell out to us what the workers' rights are? It's a broad thing here in the Constitution which says that you have the right to form and join a trade union and to participate in the activities and to strike. But where can we go find out exactly what these rights entail? Which law actually further fleshes it out, so to speak, and gives detail about what it means? How are you going to form a trade union? How are you going to join a trade union? What kind of activities you're allowed? Can you strike? When can you strike? Where is there a law that deals with this? And if so, what law is this? Any thoughts, Matemba? Okay. Can you hear me, Matemba? If you want to speak, you need to take your mic off mute, though. Because I can't hear anything from your side. Okay, you still there? Okay, good.
Yes, I'm still here.
Okay. Yeah, so my question was, where do we find, this is the Constitution here, but now where do we find the right, the further, spelling out of what this right means and the limits of this right? Where is it to be found? The right to join a trade union? Where?
In the Labor Relations Act.
Correct. Okay, so this is how we actually need to understand that this is the Constitution. The Constitution is not going to spell out in very fine and minute detail the rights the employees have. It will just put out this very broad principle here. Right? Every worker has the right to form and join a union and to participate in the activities and to strike. It doesn't tell you how do you form a union, how to join a union, how to, the activities that you can do and how you can go about your activities and striking. All those things are fleshed out in the Labor Relations Act. And therefore, when we interpret labor law, we need to go to those acts first. Okay? And the courts need to interpret those acts now in line with these constitutional principles. So that was subsection 2. Subsection 3, so do you think it's only the employees or the workers that have rights? Because if you read further, you'll see that the employers, the bosses, they also have rights of association. Just like the employees have the right to clink together and to join unions and form unions and to strike, employers, on the other hand, also have the right to form organizations of their own. And we don't call those trade unions, we call them employers' organizations. And they too can now, it's a way to quell and to counter the employees. If all the employees stand together, they become an extremely powerful force, right? They can ultimately go on a strike, which can harm the employer. They can also engage in what we call secondary strikes, where other employees of other companies, other employers, can actually strike in sympathy with the main strike, to get their demands met. So in the same way, and also to counterbalance the power that is being given to employees, the law, and in the Constitution in particular, now mentions, the employees' organizations, what they can do, what rights they are entitled to. They also have the right to associate. So what can they do? They can form and join employees' organizations, and they can also participate in activities and programs of employees' organizations. Okay? And they can also become quite powerful. So in this way, what the law is busy doing, Matemba, is to create these forces that must counter each other. Okay? And it's particularly set up in that manner, so that these two forces can actually they must speak to one another. They must bargain with one another. They must themselves come to an agreement that is mutually beneficial to them. Okay, and that is how the whole labor law system has been set up. On the one hand, you have the right of the employee to form these or rights of association and to form unions, and under circumstances they may even strike, right? Which is very damaging to an employer's, to an employer, to his business. And on the other hand, the employer also can have the right under certain circumstances. What is the employer's right? What can the employer do to counter a strike? Remember, if the employer has the right to strike and to picket and to protest, is the employer then got nothing else that they can do? What can the employer do?
Yeah, I think for the employer's side, they also have the right.
What do we call that right? They're given a very particular
yes, in terms of striking, yes, they can close their premises.
Yes. What do you call that?
And force the government to intervene.
Well, there's a word that
depending to the situation.
It's called the lockout. Okay, it's called lockout, where the employer now, if once a lawful strike has been declared, the employer can also say, well, if you're going to strike, then you can't come to work.
But tell me, lecture, how does the employer strike, man? Because yes, in some other occasions, I heard when the organizations or when they struggle in terms of the economic recession, and they propose to government to intervene. Yeah, but when they have problem with the employees, I really don't know how they approach that situation.
Yes, well, the thing is, the law is set up in such a way that they must come to their own sort of agreement about matters of what we call mutual interest. Let me explain it to you.
Sorry, I didn't hear that part. Your network was cutting.
Okay.
Yeah, I just didn't hear the last phrase you explained.
No, what I'm saying was that the law is set up in such a way
Hello?
that it doesn't. Can you hear me?
Can you hear me, lecture?
I can hear you, but can you hear me now?
Oh, damn, the network started to collapse.
Hello? Can you hear me? Hello? 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 Mr. Matemba? Hello? Can you hear me? Hello? Hello? Mr. Matemba, can you hear me? Hello? Hello? Mr. Matemba, can you hear me? Hello? Can you hear me? Hello? Can you hear me, sir? Hello? Can you hear me? Hello? 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 Can you hear me? Hello? 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 It says that my mic is working, Mr. Matemba. I don't know if you can hear me. Can you just, yeah, because you are on mute also. Hello, Mr. Matemba, can you hear me? Hello? Can you hear me, sir? Mr. Matemba? Hello? Mr. Matemba? Adele? Hello? Hello? Mr. Matemba, can you hear me? I can't hear you. I've been trying to. Can this be? Hello? Hello? Hello?
Go ahead, Mr. Alon.
Hey, Mr. Matemba, you there? Yo, I've been struggling here, man. What happened?
Yo, yeah, I lost you.
Ah,
I
okay,
lost
okay.
you.
Can you hear me now clearly?
Yeah, I hear you now.
All right. So, okay, let's get back to where we were. We were saying, is the screen there? I'll just share my screen again. Yes, these rights of the Constitution, the rights of freedom of association, so they apply. You were asking me the question about when there is this strike and also the employers have locked out employees from the workplace and government intervention is required. Is that what you were asking?
Yes, lecture.
You see, the thing is that will only obviously become this. It's a broader. It's the broad reply and the narrow reply. In the narrow reply, like in other words, if we look at it strictly from a legal point of view, that will only become relevant when the state is an employer and is involved in that situation. Okay, where the state is an employer, one of the unions that are representing the the employees of the state. And obviously state intervention is already there. But we are talking about where in the private sector, where employers who are not state employers are also involved with doing, big things like retrenching people, and it is affecting the economy, like under this, pandemic situation that we are under now. That is very like an exceptional case. We may not see such a thing in our lifetimes again, possibly, where government in fact did do that. They did join. The state did intervene when they realized that the economy was going to be shut down for a couple of months, and how it would affect the jobs and employers. And it did come up with ways to deal with that problem. Can you still hear me, Mr. Matemba? Hello? Okay. So these are the rights. A trade union, an employer has the right to form their own organization and to join with other employers. And if you look at, there's also rights that an employer has, and both employer and employees have together. If you look at Section 4 here of Section 23 of the Constitution, it says every trade union is an organization that represents employees, and every employees organization has the right to determine its own administration, programs, and activities, to organize and to form and join a federation. Okay. So what do we call this? This is basically the creation or the idea of bargaining councils. Okay. The bargaining councils are these things that the Constitution speaks of, and it's also further, mentioned in the Labor Relations Act, where employers and employees can, by themselves, enter into arrangements where they can create their own dispute resolution councils. Okay, so an example of that is the creation of the CCMA, which is a general bargaining council that's created for anybody who's got a dispute that falls under the labor laws to take it there and to have it resolved. Okay, but for certain sectors and certain industries, the employers and the employees have already created their own council, their own bargaining council, where they together, and in this bargaining council, you have employers' representatives and employees' representatives, and they, can agree how they will resolve disputes among them. Okay, instead of having it resolved outside, but through the courts or through other systems, which can, lead to delays and difficulties. Okay, and be more costly. Mr. Matemba, if you can hear me, please say so. Mr. Matemba is not there. Okay. Hello?
Yes, I'm back again, lecturer.
Okay. Yeah, because you're going in and out now. I don't think it's my connection. I'm just checking here now. It could be yours possibly.
Okay.
Huh? What do you think? Because mine is kind of working. If you can hear me now, then it means it shouldn't be any problem.
I hear you now clearly.
Anyway, so Section 23 makes provision also for those rights of employees and employers, and also for the creation of bargaining councils. Yeah, do you know what the bargaining council is? You might have heard of the CCMA, the Council for Conciliation, Mediation, and Arbitration. That is a general bargaining council where anybody who is not in a particular industry can go and take an employment dispute. So if you work for Dr. Abrams, and you have a dispute with him that the CCMA is empowered to hear in terms of the various labor laws, and you can take your dispute there. You don't go to the courts as a matter to resolve your dispute. The CCMA is basically the first way where you can resolve your dispute in a cheaper and quicker way. But the CCMA is your general bargaining council. You do get other bargaining councils in the different sectors, in the teaching sector, where the government is an employer, in the various other industries like engineering or the food industry, the clothing industry. There, the employer and the employees are encouraged in terms of that section of the Constitution, and also in the Labor Relations Act, where it is now spelled out how the two of them, the employers and the employees, through their representative organizations, can create their own bargaining councils. Okay, so instead of going to the CCMA, they will go to a bargaining council of their own making, so that they can resolve disputes amongst themselves in a quicker and cheaper way. And the law allows it. The Constitution actually encourages that. Okay. Then there's this other term. You can hear me, Mr. Matemba? Then there's this other term here in section 5.
With you.
Yeah, if you look at this here, where all these rights stem from. If you look at them, why are we doing what we're doing? You know, in the labor world, why are people striking? What are they doing that for? It's because the law allows them. Okay, why is this happening? Why is it happening? It all comes from the Constitution. So also, what the Constitution and the LRA in particular wants employers and employees to do, it wants to force them. In reality, it wants to actually force them into a situation where they are, or they've got no choice but to come to an agreement between themselves regarding matters of mutual interest between them. Okay? So if you look at section 5 here, it says that every trade union and employees organization has the right to engage in collective bargaining. And the collective bargaining is the prize that these these parties are trying to achieve. Okay, they don't want to involve. The law is basically set out the perimeters. You know, it has said these are your rights, but don't come to the courts, don't come to parliament really if you can't, you know, to fight about a wage increase or to fight about working conditions or to fight about, you know, the law has already been set out. It is up to you guys, employer and employee, to try and bargain, number one, and number two, to come to an agreement which will be binding on you. And that is the collective agreement. Okay, of course, this right doesn't include everybody, this freedom of association. So broadly speaking, those were the rights of freedom of association, as I mentioned. But there are people that are excluded from it, and because of their particular occupation, just like the Basic Conditions of Employment Act and the LRA, you know, don't apply to members of the Defense Force or the Secret Service. There are people that are not protected under the LRA, but they are nonetheless still protected under the Constitution in terms of Section 23, subsection 1. Okay, so these include certain members, like Defense Force members and so on. And it was also decided in this particular case, South African Defense Union versus the Minister of Defense, where they felt that, you know, the Constitution doesn't give us, well, the law, the Labor Relations Act gives all these rights, but what about us? Don't we have the right of freedom of association? And they do. They also have the right of freedom of association to create these things, but they are regulated differently. They are not regulated under the Labor Relations Act. Okay. So all this broad freedom of association rights, like with any right, there are limitations to it. You know, you cannot do things. The whole idea is so that employers and employees can basically come to a collective agreement. It's easier said than done, you know, and therefore, if there is some wisdom. Of course, people have criticized the idea that why must people be forced to go and ultimately go strike, and why must the employers lock them out? Can't the government then just make a law? And like I said, this is the plan behind the government was to force these parties to resolve their disputes regarding work conditions and matters of mutual interest amongst themselves. Okay. Okay. So a trade union, okay, is basically where it's like the flagship of an right, freedom of association right. In other words, by that I mean it is the best of all the rights that an employee, collective employees can have together, right? When they are given, they register the trade union, although they don't have to, they register the trade union, and once they register the trade union, they get all these other rights that go with it, right? And we will come to that in a moment. You know, what you get once you register. And even if you don't register, there are other ways that you can also, because of your broad rights of freedom of association and organizational rights, that you can also have closed shop and agency shop agreements, okay, where it is not as formal as trade unions and collective agreements, so to speak, but it allows where the situation where there's no formal trade union, but the number of employees are not as high to warrant a union being formed, but there are other arrangements that you can nonetheless enter into, but the employees can enter into with their employers. Okay, and these are called closed shop and agency shop agreements. Okay. Now, what is an agency shop agreement? And you can look here. An agency agreement is concluded by the majority union and the employer, and is concluded by way of a collective agreement. Now, this term is going to come up a lot all the time, collective agreement. And you must understand what it is meant. You know, it is that agreement is so widely or so highly regarded in terms of, the Constitution mentions it. The Constitution says, look, you employees and employers must enter into agreements, man, regarding matters between yourselves of mutual interest. Right? And that once you reach that agreement, this collective agreement, it will bind you. And it can even, surpass certain laws, as long as these laws and also your collective agreement don't go against the Constitution. But you guys must have try and achieve entering into and concluding a collective agreement. Now, one of the constitutional rights, if you recall, was that now once you can form your trade union, you can do all these activities. The agency shop agreement is a lower form of it, and you get all these certain rights. So an employer, for example, once you've got such an agreement in place, must give the union the right to elect their representatives, called shop stewards. The shop steward can do union activities. In other words, he may end up not even doing the work of the employer, while arranging union activities and these kinds of things. Yet the employer will have to pay him. One. Two, you also entitled, once you're registered as a trade union and a majority trade union, because you'll find in some workplaces there are not that many, there are like so many workers that they all can't agree for one union to represent them. There may even be two unions in the workplace. Okay, so the one that represents the majority of workers will have certain benefits, and that includes, like I mentioned, those rights of activities and entering the workplace and having meetings, and also deducting money from the employees' wages for membership of the trade union, so that they can fund the activities. Okay, so that is your agency shop agreement. So how's the closed shop agreement? You can see here. Okay, again, it's where there's no formal union as such or union, but they have this agreement in place where 2/3 of the employees vote in favor of the agreement. And here, unlike the agency shop, the closed shop, you can't deduct monies from the employees' salaries and their wages for fees. Okay. Okay, so these are variations of all this rights of association, okay, which we need to become familiar with. And why do you want to form these unions? I mean, we said it before, so we can get all these rights. And let's quickly look at them, these organizational rights. Because what's the purpose of having the right of freedom of association and to join unions, make unions, but now the employer stifles you, stops you from, doing anything meaningful, for you to be able to exercise your right. In that case, then what is the point? So the Constitution again guarantees these rights, and these are your organizational rights. So when we speak of organizational rights, and you might get a question like this in your paper, in your exam paper, so look out for it. And these are the 5 organizational rights that are provided for in the Labor Relations Act. All right, so what do you get now once you have you have either a trade union or a closed shop or agency shop agreement. Remember, those are the lower forms, the agency shop and the closed shop agreements. Okay, they have these small variations to a full-on trade union. So what do you get once you are afforded organizational rights? Not all of them. A full-on trade union, a majority trade union will get all 5. A closed shop may not get all 5. Okay, maybe 1 or 2 things that they may not be able to get. So let's just look at these rights. The right of access to the premises of the employer. So the employer can't chase an employee away for wanting to do union activities. So he has the right to come onto the premises and do it, which is a big thing. You know, to form and create a union is actually a process in itself. The Labor Relations Act tells you how you must go about to do it. You must register this organization. You know, there's a process to do it. Okay, and to how you're going to acquire, because you can't acquire them so easily. You need to acquire them either as a union or in certain circumstances through your closed shop or agency shop agreement. Okay, so you want to get yourself organized, you want to put yourself in a better footing, being in the position of the workers. The right to have trade union membership fees deducted by way of stop order. So we know that this right is not given to closed shop agreements, it's given to trade unions. Okay, and the employer must now deduct that monies from the workers' salaries and wages and pay it over to the trade union every month. The right to elect shop stewards. I don't know, in the course of your work, Mr. Matemba, whether you're familiar with a shop steward. Do you know what a shop steward is? Mr. Matemba? Hello? Hello? Mr. Matemba, you there? Hello?
Yes, I'm with you.
Yes, and so can you tell me, have you heard of a shop steward? And do you know what the shop steward is?
Yes, a shop steward is an employee, the one appointed by the other employee, for the fellow employer, for the fellow employees to represent them when it comes to the disease, which is disciplinary hearings.
That is only one of the things, but you're right. It's basically a representative now, a fellow employee who the employees have elected to represent the trade union. And the trade union in turn represents all the workers. And there could be more than one shop steward. And often they are in large organizations, in large employers. So, you know, for example, you know, when it comes to unfair dismissals in the workplace, when an employee has committed something, you know, and he's been given a notice to attend a disciplinary hearing. Very often, you know, the standard one under the unions in many industries and sectors is that you're entitled at that disciplinary hearing to have your shop steward present there, a shop steward or a fellow employee there to help you. Okay. Now that is not something that has been enshrined in the LRA, but it is a product of a collective agreement. You know, the workers have entered into agreements and have bargained and negotiated that term with the employers to make sure that in the event of disciplinary hearings that they can be assisted by shop stewards. So yes, you have the right to have shop stewards, the right of shop stewards to get time off for trade union activities. So this is a bit of a sore for the employer, because while you find this worker who you employed to do work for you, the employer, once he's a shop steward, he may be using most of his time to do trade union activities. And must the employer pay him for this while he's doing trade union activities? Good evening, Tammy. Can you hear me?
Your question again, lecture?
I'm saying, like, one of the rights, the shop stewards, you can elect your shop steward, but does the shop steward, he's also entitled to get time off for trade union activities. Now, in the bigger organizations, the shop stewards are so busy that they don't actually have time for work, for actual work. Because you did say the shop steward is an employee of the employer. But now the LRA says that one of the organizational rights are that you can elect your shop steward and that the shop steward must be given time off for trade union activities. And like I mentioned now, in some organizations, in some workplaces, the trade union activities are quite, they're very active. There's a lot of work to do, and they don't even have time to do their own job that they were employed to do. Now, what about that? Must the employer still pay the shop steward while he's doing that, doing union activities?
Yes, lecture.
Yes.
The shop stewards, they are entitled to their salaries.
Yes.
Remember, there is no limit when we talk about the union activities.
Yeah.
It didn't set a certain portion of the job. You understand?
So you understand?
They are obliged. It's the loss of the employer for those situations whereby the employee must take more time out of their jobs. Actually, their job of their duties. It is the loss to the employer, but they are entitled to pay them, irrespective of what the circumstances are, in the activities of trade union.
Okay, good point, because it becomes a bone of contention between the employee and the shop steward, right? Then another right, organizational right, is the right to disclosure of information. What do you think that could entail? Employees have the right to disclosure of information, which is a very, intrusive right, you could argue.
This network contacted me back again.
Say again? Everything okay? Okay, so I want to know, what is this right to disclosure of information that you have under an organizational right? Right, and does it apply to a full or majority trade union, to agency agreement, close-up agreement? Who has the right to disclosure of information, and what exactly does the right entail?
Okay, about the disclosure of information. Yeah, I think the shop steward, they have an access to the statements of the organizations. Yeah, but in terms of disclosing the information, like you have to disclose it to his trade union.
Yes. So number one, this disclosure of information, it includes relevant information. Okay, so when there is a dispute, for example, if the employer is insisting that, for example, that they want to retrench people, they will go to dismiss people due to operational requirements. Right? The business has gone through a change, and the reason that the employer is giving is, look, we're not making enough money, and we can't sustain all the employees, and therefore we're going to have to look at retrenching people. The only way that the employee can challenge that decision, without any, with a true basis, is to actually have regard and to have access to the employer's financial information. Right, and many things have happened during this process of discussion and negotiation between trade unions or employees and employers. Okay, a couple of years ago, I don't know if you remember, there was the the Living Hands Trust. You know, there was a guy called Arthur Brown. I don't know if anybody can remember this gentleman who was at the head of some big scandal where they had taken monies from, you know, monies that belonged to, that was supposed to be invested on behalf of mine workers, you know, in a fund that was to be, monies were to be invested to protect workers in the event that they got hurt or injured, or if they died in mine accidents. Okay, and the company had actually handed over the money, I believe, in good faith to this particular investment company called In Living Hands, which was under the control of a gentleman called Arthur Brown. And when Mr. Arthur Brown, it was about 3 or 4 billion rand. And when the monies was handed over to this investment company, it was squandered and taken and defrauded. Okay, and this was kept a secret for a short while until the employees invoked this right of disclosure of information. All right, and it was in the course of that disclosure that they came across the details that, oh, the monies, you're telling us that we can't get claims and people aren't being paid out for you know, for injury claims and for death claims and for family benefit claims, you know, and the employer couldn't justify it. But when the information came to light, they learned very quickly that the money had been squandered. So this is a very important right to have. The Constitution gives it to employees, to trade unions, for good reason also. And that is to see, in a case like this, if we're fighting about money, you know, then show us your financial statements. That would be a relevant document. Okay. Any questions on this? And here you can see in detail. We've discussed this already. You can see under disclosure of information, the employer cannot be expected to disclose information which isn't available, is not relevant, is legally privileged, could harm the employer's business interest if disclosed, and is private personal information relating to an employee unless the employee is consented. Okay. Now, representativity, I mentioned this earlier, that let's just go back. We've got those rights as employees, the right to freedom of association, the right, these organizational rights, you know, to form organizations. And because employees are numerous, they're not all of the same mind. They may have different views, they have different choices that they want to, you know, they have and they want to make about who represents them. So now we know what the organizational rights are. Now, who's entitled to it in the workplace? So, and this will depend on the representativity of trade unions in the workplace. Okay, so there's two types: the majority, and that should basically make you think, yeah, that's the majority. And if you're the majority, then you would be entitled to all those organizational rights that we mentioned here: access to the workplace, take money from the wages, elect shop stewards, give the shop stewards time to do union activities, and disclosure of information. You can only get that if you are the majority union normally. Okay. If you are what we call sufficiently representative, okay, it may well be that the workforce could be divided even into, there could be a majority, but you know, there could be further breakups, but it only speaks of sufficient representation. And if you are sufficiently represented, you're entitled to certain organizational rights. These are the organizational rights again. And not all of them. Only the majority union is entitled to all of the organizational rights. Now, who gets what? Who gets what in the workplace? So we know we've got the majority union and we've got the sufficiently representative union. So there you go. I've said, once you have the majority, and the majority is 50 plus 1, 51%, and then you get all the organizational rights. If you are sufficiently represented, look at the rights that you do get now. And look at the rights that you don't get. You get access to the workplace as a sufficiently represented union. You can take the fees from the workers, right, for the membership fees for the union, and you can get shop stewards to be elected and also to take time off. But the one thing you don't get then is disclosure of information. Okay, so it means that the employer, you know, would still have some advantage over this minority union. But remember, I'm going to ask this question again, and I will ask it: why is this all in place to give all these people these rights? To increase the bargaining power and the bargaining position of the employees. Okay, to try and bring it up to the level of the employer, so that the employer and the employee can treat each other with certain amount of fairness, and that they can meaningfully negotiate and come to a fairly reflective collective agreement in the end. What did I say the bargaining council is, Mr. Matemba? During that time, I think you had some bad connection. But what can you tell me is the bargaining council again? Just a recap. Of the bargaining council. Remember, the bargaining council is the idea that not only must the parties come to an agreement, like a collective agreement, where they agree on matters of mutual interest between them, but the Constitution and the LRA wants them actually in certain sectors to create their own dispute resolution forums and organizations. Those are called the bargaining councils. If you don't belong to a union and you got a dispute, where can you take your dispute if you're an employee? Let's say, Tammy, you get dismissed tomorrow, and if you're working at this, and you're unhappy because it was an unfair dismissal, then where you gonna go? Where would you go? Where would you go to, Mr. Matemba?
If I'm on a bargaining, if I belong to the bargaining council, I'll obviously go to the bargaining unit. Right. Yeah, and if I'm a normal, well, not a normal person, but if I don't belong to the bargaining council, then I would go to the CCMA.
Right. Thank you. Exactly right. So now you can see where the idea comes from, okay? The idea that where do these bargaining councils come from? They come from the Constitution, fleshed out in detail by the LRA, which encourages employers and employees to create their own bargaining councils if it so permits, okay? There's a procedure that they enact to create it. So you need cooperation. You need both employer and employee to work together to be able to have an organization, a bargaining council, where you both, can have your disputes resolved. You're both represented there, and you both have interest there. Okay, so that is a great step in going to, to furthering the idea that to put the employees and employers on a more equal footing. So how do you acquire? The next question is then, we know what organizational rights are now, right? Here's a reminder. We know that they get them, depending on how well you're represented in the workplace, will determine how much of these organizational rights you will acquire. You're either a majority trade union or a representative trade union. But now the question becomes, how do you get these rights? Okay. And here you must list them here, a collective agreement. Now, what is a collective agreement? The collective agreement is mentioned in the Constitution and the LRA. That is the agreement that the parties must actually arrive at. Okay, between the organized employees and the employers. Okay, this is the grand prize that you as workers and bosses must come to. You know, and now you regulate all your matters of mutual interest between the two of you. Your workplace conditions, perhaps, times of work, payment, you know, disputes about wages. Those are things that are of mutual interest to you. Okay, so you need to, the one way to acquire your organizational rights is to actually coming to them by agreement. Okay, which is not always ideal. You know, it's not always, what I mean is it is ideal, but it's not always easy to reach a collective agreement. And therefore, the act itself, as we will come see later, that it kind of creates a pressure situation for both sides. You know, that they're forcing them to a certain situation, and they're given time periods also by which they must come to agreements, failing which it becomes like the explosion. And the explosion is striking on the one hand by the employees and locking out on the other hand by the employers. So you can get your organizational rights. Now remember, you know, we started off by saying that the employees must now, you know, get their organizational rights. Are organizational rights only the preserve or only restricted to the employees? You know, yeah, you can now want this in your collective agreement. You know, this is how we're going to have our wages paid, our working conditions, our times, how our wages will increase. We're not going to look into this, how if there's a dispute, how we're going to resolve it. But now, is it only, the collective agreement only contain the rights of the employees, of the workers? What else do you think will be contained in a collective agreement? I mean, other than employees' rights, of course, broadly mentioned. You will also have the employers' rights in there. Remember, organizational rights in terms of Section 23 not only is covered by, or you know, entitled to by employees, but employers themselves can also now use the opportunity to make sure that their rights are also put in there, and they also have rights of freedom of association. They can also link up with other and join other organizations, employers' organizations. Okay, so it is the right of freedom of association is a right extended to both employees and employers. So we're just discussing how you can acquire your organizational rights through collective agreement, through membership of a bargaining council. So obviously the bargaining council is the one of the more advanced you know, rights under Section 23 of the Constitutional Labor Rights. The bargaining council comes about when the employers and employees have already agreed that, look, let's form this council where we will send all our disputes that, you know, we have with the workers and the employers. So if you've become a member there, you know, when you once you've agreed and you've actually created the bargaining council, you know, it's one easier way to get people and employees to you know, fall under standard terms of a collective agreement is to require them to become members, and secondly, that upon their membership they must agree to collective agreements that are in place. Okay, so that is the other way. And of course, the extreme way, if collective agreements, which are agreements that are normally, you know, arrived at or concluded after the parties have now spoken and negotiated, right? If that is not reached, okay, if you can't come to an agreement, a collective agreement, then it is, you know, there's normally like an arbitration process not arbitration, but a mediation process, which if failed, moves to strike action. Okay, and we'll come later to section 64, 65 of the LRA that says what sets out the procedure for strike action. That if the parties now is a matter of mutual interest that they can't resolve, and they've referred it to the CCMA to have it resolved, and it remains unresolved for 30 days, or either party doesn't want to participate in the process, and a certificate is issued by the CCMA saying that the matter remains unresolved, or for 30 days they've been talking and nothing, they haven't resolved it, then parties, the employees, may declare strike after giving a certain period of notice. So strike action, and strike action is the worst action. As I've mentioned, it's not always productive, but I mean,